the bill. I call Virginia Crosby.
Yeah.
Thank you, Chair. It's an absolute pleasure to serve under your chairmanship and to bring this bill, the Employment Allocation of Tips Bill, through to committee stage. I'd like to give my sincere thanks to the Honourable Member for Watford and congratulate him on becoming a Minister. It was he who first tabled this important private members' bill and did so much work to get it to this stage. This is a groundbreaking piece of legislation that will benefit millions of workers, and I'm honoured that the Minister has asked me to sponsor this bill with government and cross-party support. This bill is all about fairness. I entered politics to be a voice for others. The hourly pay in hospitality is one of the lowest in all sectors of the UK, and this bill will potentially benefit over 2 million people, 7% of workers in the UK who receive tips as part of their work.
Would you give way?
Of course I'll give way.
Absolutely. Thank you. I'd like to thank the Honourable Member for giving way. Actually, my son Liam Eastwood works in the hospitality industry, and he's quite fortunate that he keeps all of his tips, which supplements actually quite a decent wage that he gets paid as well. Would my honourable friend agree with me that, contrary to what some on the left are saying, this bill ensures fairness in allocating tips and is not an attempt to reduce a decent living wage?
Thank you. May I thank the Honourable Member, who is a hard-working champion and an advocate for his constituents in Dewsbury. And I've been hearing about his son, Liam, and how he's been working. I would highlight that this bill has so much cross-party support, and it's great to see how we're all working together to make a significant change to these workers in the hospitality sector who are particularly having a tough time at the moment. Thank you. This bill will potentially benefit over 2 million people, 7% of workers in the UK who receive tips as part of their work. And it will ensure fairness across the board, so that whether people work in Pete's Burger Bar in Holyhead or serve fine dining at the Gerwin Arms, they'll be treated fairly and equitably. Places in dire need of levelling up, like my constituency of Ynysmore and other coastal and rural communities, are often home to thousands of people employed in tourism and hospitality. And local employers on Anglesey include the Sandymount Hotel, Sergio's, the Sea Shanty, Catch-22, the Oyster Catcher, Dillon's and the White Eagle. So many to mention. I'm sure all colleagues and members here have the same story to tell. I was the first one in my family to stay on at school beyond the age of 16, and it was the hospitality sector, working in restaurants, pubs and cafes like the Mercury Cafe and Fifi's restaurant, that helped me pay my way through sixth form and university. The tips I earned were spent on a new winter coat or a pair of warm boots. And whilst there's a drive for better hospitality career opportunities and pay being driven by the likes of Aled Jones-Griffith and his team at Coleg Menai, jobs in these sectors are often seasonal and poorly paid. And for many workers, tips form an important part of their potential earnings, particularly in these challenging times. And while most employers do distribute tips fairly and honestly, this is not the case for everyone. This is what this bill seeks to address. I'll deal with clauses 1 to 14 together. The provisions create a legal obligation on employers to pass on tips to workers in full, and the only deductions permitted are those required or permitted under other statutory provisions such as tax law. This will promote fairness for workers and ensure they receive the tips they earn. The vast majority of customers give tips on the assumption that they will go to the workers and do not expect businesses to take a slice of this. Likewise, workers rightly expect to receive their tips in full in recognition of their hard work. The bill will also provide greater transparency for employers and workers in terms of how tips should be treated. And it will create a level playing field for businesses who will already pass on tips to workers in a fair and transparent way. Finally, consumers will have the confidence that the full value of their tips will go to workers. I'll now set the detail of the clauses out before the committee. Clause 1 inserts a new part into the Employment Rights Act 1996 to set out how employers must deal with qualifying tips, gratuities and service charges, which I will refer to as tips. The bill will apply to all tips paid by a customer to an employer, including tips paid by card, which are usually paid into the employer's bank account. 80% of tipping is now paid by card. The bill will also apply to tips paid directly to a worker if the employer controls or influences the allocation of tips. For example, where the employer tells workers how to share the tips between themselves. The bill will not apply to tips received by workers where an employer or association person does not control or significantly influence the allocation of the tip. The clause aims to capture all scenarios where an employer has control over tip allocation and distribution to prevent them from taking advantage of this to exploit workers. The clause provides that tip, gratuity or service charge means the actual amount paid to the customer. Employers cannot make deductions for things like processing fees. This ensures that workers receive the full amount of tips. Clause 2 introduces a fairness requirement. This requires employers to ensure that the total amount of tips is allocated fairly between workers of the employer at the place of business where the tips were paid. This means, for example, that tips paid by customers at a particular restaurant will not be shared with workers at a different restaurant of the same employer. In determining how to allocate tips fairly, the employer must have regard to the relevant provisions of the Code of Practice, which is described in later clauses. The amount of tips allocated to a worker is payable to the worker by the employer. And Clause 3 sets out how the employer's obligations apply where tips are allocated by an independent tronc. The bill allows for tips to be allocated by an independent tronc as long as the arrangements are fair overall, having regard to the Code of Practice. The word tronc comes from the French word for alms box. It's about pooling tips and redistributing the tips. This can be employer-controlled or independently operated by a member of the staff or a payroll or accounting company. Tipping practices vary between employers, and the bill seeks to support these diverse practices as long as they are fair. The clause also provides that tips can be payable to workers by independent tronc operators, either directly or through the employer's payroll. Clause 4 details when tips must be dealt with. The clause sets out that an employer must ensure that tips are allocated to workers and paid no later than the end of the month following the month in which they were paid by the customer. For example, if a tip was paid on the 8th of April, the employer would need to deal with the tip by the 31st of May. Clause 5 sets out how an employer's obligations with regard to tips apply to agency workers. Agency workers are workers who are supplied by an agency to work for a business, for example, to work for a restaurant. They benefit from the bill, and they will be treated as if they were workers directly employed by the restaurant. This ensures that agency workers do not miss out on tips that they have earned. The clause defines which agency workers are eligible to be covered by the protections relating to tips. It requires tips to be fairly allocated to eligible agency workers. The clause allows a business to pay the agency worker's share of the tips to the agency, who must then pay that sum to the agency worker. This is because agency workers are often not on the business payroll. Clause 6 concerns the written policy and records employers must keep of tips. All employers who deal with tips on more than an occasional or exceptional basis are required to have a written policy on dealing with tips. The written policy must include whether the employer requires or encourages customers to pay tips and how the employer ensures that all tips are dealt with in accordance with this legislation, including how the employer allocates tips. The clause also sets out a requirement for the employer to make the written policy available to all workers of the employer at that place of business. Employers are also required to keep records relating to tips. Records must be kept for 3 years and must include the total amount of tips paid, the amount allocated to workers, and if relevant, the amount allocated to an independent tronc operator. The requirement to keep records is essential to ensure that workers have access to the information they may need to enforce their rights. And the clause provides workers with the right to make a written request to access limited relevant parts of their employer's tipping records. This allows workers to gather evidence to seek redress if they are not being treated fairly. Clause 7 explains the enforcement mechanism for employers' obligations regarding tips. The clause provides that workers can present complaints to an employment tribunal that an employer has failed to comply with their obligation to allocate tips fairly or failed to do so in time. The clause also allows agency workers to present complaints. The limited period for these complaints is 12 months. Workers' rights to bring forward these claims are at the core of this bill, as employment rights need to be underpinned by effective enforcement. The clause sets out how a tribunal should determine complaints about tips. Where a complaint by a worker is well-founded, the tribunal must make a declaration to that effect. The tribunal can also make a range of orders, including an order requiring the employer to revise any allocation of tips they've made, or an order requiring the employer to make a payment to a worker of up to £5,000 to compensate them for consequential financial loss. Clause 8 explains how workers can complain of their employer breaches and the information provisions in this bill. This includes if an employer fails to comply with the requirements relating to written policies dealing with tips, records of how tips have been dealt with, or workers' written requests for information. Workers can bring forward a claim to an employment tribunal in these circumstances. The limitation period is 3 months. Workers' rights to bring forward these claims are essential to this bill, as assessing this information allows employers to be held accountable and workers to check that what they are being paid is correct and fair. The clause sets out how a tribunal should determine complaints about the employer's policy or record-keeping obligations. Where a complaint by a worker is well-founded, the clause states that the tribunal must make a declaration to that effect. A tribunal can also order a payment from the employer to a worker of up to £5,000 to compensate them for consequential financial loss. Clause 9 gives the Secretary of State powers to issue, revise and revoke a code of practice for the purpose of promoting fairness and transparency in the distribution of tips. The code of practice is necessary to help describe different circumstances that are fair and unfair in more detail than the bill could. The code can also be adapted to changing circumstances in future more easily than primary legislation. To issue a code of practice, the Secretary of State must consult ACAS and publish a draft to allow stakeholders to make representations before laying the draft before both Houses of Parliament for approval. The clause also establishes the procedure to revise or revoke the code. The clause details the legal effect of the code. It sets out that the code is admissible as evidence in proceedings before an employment tribunal and, where relevant, must be taken into account. Clause 10 sets out some additional provisions relating to tips. It prevents employers from bringing restitution claims against workers in respect of tips. If an employer is ordered to revise their allocation of tips and they have over-allocated tips to a worker, those tips are not repairable from the worker to the employer. The clause also preserves existing contractual arrangements relating to tips. This means that if a worker was already entitled by their contract to receive a certain percentage of qualifying tips, they will remain entitled to these tips despite the passage of the bill. However, payments under the statutory and any contractual obligations can be set off against each other to avoid double counting. The clause also prevents workers from opting out of their rights under this bill. The clause provides some further definitions, including customer and place of business. It clarifies certain situations where it's unclear which place of business a tip is attributable to. The clause provides that the bill applies to tips paid by customers on or after the date when the obligation to allocate tips fairly comes into force. The bill is not retrospective. Clause 11 amends certain provisions of the Employment Rights Act 1996 with regard to tips. It clarifies that a worker cannot contract out of or consent to amend their right to receive tips that have been allocated to them by their employer. It also amends the definition of wages to include tips. Clause 12 amends other pieces of employment legislation as required, and this is because some acts require amendments to ensure the provisions apply correctly and cohesively once the bill comes into force. Clause 13 sets out where the provisions of the bill apply within the United Kingdom. The clause provides that the bill regulates qualifying tips paid at or otherwise attributable to a place of business located in England, Wales or Scotland, and this legislation does not regulate tips in Northern Ireland because employment law is devolved to Northern Ireland. Clause 14 is the final clause apart from the title. It defines how and when the bill comes into force. The clause confers the power on the Secretary of State to determine when clauses 1 to 12 of the bill come into force by making regulations. Clauses 13 to 15 come into force the day the bill is passed. I'd like to close by thanking the Chair, the officials for working so hard to make this bill a success, and everyone here for supporting the bill. And once again, to particularly thank the Honourable Member for Watford for putting his faith in me and for everything he has done to bring the bill thus far. We all want workers to be treated fairly, and we all want to see the rewards for hard work distributed to those they are meant for. It's a great opportunity for stakeholders also to engage in the code of practice. Let us work together to make sure that this bill achieves what it set out to do. David Linton.